Good morning, everyone. Those of you who are participating in this morning's workshop in the hearing room and our virtual participants, I'm Jocelyn Boyd. I'm employed by the Public Service Commission. On June 6, 2025, the clerk's office issued a notice of workshop regarding the definition of working papers, and the notice was published in non-docket number 2025-41A. In that notice, the commission staff stated that it intended to conduct a workshop related to the definition of the term working papers. The workshop was scheduled for July 16, 2025 at 10 o'clock in the commission's hearing room. And the staff, prior to issuing that notice, of course, internally worked on the language that appears in the notice of workshop, the notice dated June 6, 2025. Staff asked that any interested stakeholder who was interested in participating in the workshop should inform the commission on or before July 8th, 2025 of the stakeholders' intent to participate and to also file written comments on or before July 8th, 2025. So everyone, just by way of background, a little bit of background, if you're not aware, during the legislative review process of Regulation 103-833 earlier this year, during one of the meetings that was held to review the regulation, Ms. Purvis, would you please display that regulation? Thank you. The final regulation, which for 103-833, which relates to written interrogatories and requests for production of documents and things, the Public Service Commission filed a final regulation for General Assembly review that added the words working papers, re-added the words actually to 103-833. And during that, at least one of the hearings, the commission staff was asked about the definition of the words working papers, which resulted in basically why staff has now issued the notice of workshop. Staff's intent with issuing and conducting today's workshop is to follow through with issuing a notice of drafting within the next month in August. And then it's our intent to also issue the proposed regulation for General Assembly review in January. So that's if you weren't already aware, that is the purpose of staff issuing the notice of workshop for today and asking for stakeholders' comments prior to starting this process. Okay? So if you don't mind, if we can, at this point, just ask who is participating today. I will start with, and I have printed the information from the docket management system, and it appears as if Dominion Energy South Carolina, after the notice of workshop was issued, filed the first notice of appearance. So may I ask who's appearing on behalf of Dominion Energy South Carolina?
Good morning, Ms. Boyd. I'm Chad Burgess, and Elizabeth Hutton is back in the gallery. We're both in-house corporate counsel for Dominion Energy South Carolina, and with us today is Michael Anselmo from the law firm of McGuire Woods, who serves as the company's outside counsel.
Thank you. Thank you for being present, and thank you for participating today. Duke Energy Carolinas and Duke Energy Progress.
Good morning, Ms. Boyd. Tekla Henderson and Lyle Treywick on behalf of the companies.
Thank you, Ms. Henderson and Mr. Treywick, for being present and participating. And then I see Mr. Anselmo was next. And then we have the Office of Regulatory Staff. You were automatically a participant, Mr. Muschin, but.
Yes, ma'am. Ben Muschin on behalf of ORS.
Thank you. South Carolina Telephone Coalition.
Good morning, Nanette Edwards with the law firm Burr Foreman, and I'm here with my partner, Tracy Green.
Okay, thank you. Thank you, Mr. Green and Ms. Edwards, for participating. Piedmont Natural Gas Company.
Good morning, Ms. Boyd. I'm Jason Richardson of McGuire Woods, LLP, outside counsel for Piedmont Natural Gas.
Thank you for being here and participating. South Carolina Department of Consumer Affairs.
Hi, good morning, Ms. Boyd. Roger Hall on behalf of the department.
Thank you, Mr. Hall, for participating. Southern Environmental Law Center and Sierra Club, and it's my understanding Ms. Mixon, Sierra Club is not participating today.
That's correct. Good morning. I'm Kate Mixon for Southern Environmental Law Center.
Thank you, Ms. Mixon. I'm going to call their name, but I don't think they're participating today. They did file written comments. Carolina's Clean Energy Business Association. All right. And then Mr. Charlie Terraney.
Good morning, Charlie Terraney, Pro Se.
Pro Se. Good morning, Mr. Terraney, and thank you for participating. So this is a workshop, everybody. Does anyone have you've seen the draft that staff just basically, I will tell you the method to our madness. So the team that worked with me on this included myself, two of our CPAs, one who works in the finance area and one who actually works on cases with the commission. And let's see who else was in the room. Our paralegal, one of our paralegals. And so what we did is we looked at GAP. We looked at, because we were looking for the words working papers and work papers, just to see. We did a search of the South Carolina Code and look for those terms in the South Carolina Code. Hold on, let me see if I can find my document, if you don't mind, everyone. We looked at several sources to try to create this draft definition. Okay, yeah, we found, for example, a reference to work papers under Title 38, which deals with insurance. Work papers are also mentioned in FOIA. If it's not work papers, it's working papers. Let me go down to some of our, so basically we looked through the South Carolina Code first just to find the term, even though we know that what the purpose of the reference in the commission's regulations may not necessarily relate to all of these other sources. We searched some federal regulations and we kept a list of all the sources that we found in the South Carolina Code that reference either work papers or working papers. And as I said, then we looked at some accounting sources and audit, the audit rules for auditors who conduct, professionals who conduct audits, financial audits, to try to create the draft regulation that is included in the notice for today. So Ms. Mixon filed on behalf of her, the Southern Environmental Law Center and the Sierra Club filed a modified proposal of the definition. And I thought about asking if anyone objects to Ms. Mixon beginning the discussion about her draft, because everyone has seen what staff compiled. And then getting comments about Ms. Mixon's draft, if Ms. Mixon is okay with that, and or any other comments that anyone else wants to provide. Does anybody have a problem with that approach? Okay, Ms. Mixon, I didn't talk to you about this, but I hope it's okay for you to go first.
Yes, can you hear me okay?
Yes, ma'am.
Great. Again, Kate Mixon with Southern Environmental Law Center. Appreciate the opportunity to provide comments. We filed comments jointly with the Sierra Club, but as you noted, they are not able to join the workshop today. I'll also start by saying, I think our comments largely align with the written comments from the Department of Consumer Affairs as well. essentially we agree. So our understanding is that the stated purpose in the revisions to Regulation 103-833A regarding hearing preparation working papers was to align that regulation with Rule 26 to provide a trial preparation protection for communications between a party's attorneys and expert witnesses. And Rule 26B3 does protect those communications, but Rule 26B4D then provides 3 exceptions for that rule and states that materials are discoverable when they relate to an expert's compensation, when they identify facts or data that the party's attorney provided and that the expert considered in forming the opinions expressed, or when they identify assumptions, again, provided by the party's attorney, and that the expert relied on informing the opinions in testimony. And so in other words, Rule 26 makes clear that any facts or data on which an expert relies in forming the opinions in their testimony are not exempt from discovery. The definition of working papers in the commission's notice, it includes working papers prepared for a pending proceeding. In our view, that definition could include working papers that include, again, the facts and data an expert relies on to form their testimony. Those work papers are not and should not be exempt from discovery and are critical to understanding or reviewing essentially any application or expert testimony in PSC proceedings. And so our view is that if the commission's intent in defining working papers here is to delineate which materials would not be discoverable under the revised Regulation 103-833A, our view is that definition should then be specific to hearing preparation working papers, not all working papers, and make clear that any materials relied on in forming an expert's testimony would be discoverable in accordance with Rule 26B3 and B4D. And again, we provided a revised definition in our comments.
Yes, ma'am. Thank you. Thank you for the grammatical changes that you made also in your proposal. Okay. Ms. Mixon, is that it right now? For right now?
Yes.
Okay. Thank you very much for going first. So then, if you all don't mind, I'd like to move to Mr. Hall, who to see your comments about what if you would please share your comments about Ms. Mixon's proposal and anything else you want to share, please, Mr. Hall.
Sure. Thank you, Jocelyn. I guess starting with their definition, I mean, I think it helps provide clarity, but ultimately, like we said in our comment letter, I don't think any new definition is needed at this time. The commission previously found when the department suggested definitions during the prior reg review, and we also suggested just to make clear that working papers does not include work papers, which obviously the proposed definition explicitly includes work papers, but we agree with Ms. Mixon that it's overly broad, that it's going to encompass a lot of materials that not just the department or Southern Environmental Law Center, but that every party asked for. I believe we included a footnote in our comments to one of Duke's last rate cases where every party in their first discovery request asked every other party for work papers supporting materials. So that being said, I think it has worked. We did mention before that there were a couple of times, particularly when I first started at the department, that we received objections when we asked for work papers because of the word working papers. We were able to work through those and didn't involve the commission. Hasn't been an issue since. The commission recognized that in the prior reg review and found that it was unnecessary at that time. So if it was unnecessary then, we think it's unnecessary now, and would just suggest that no changes are needed at this time. Again, with the definition proposed by SCLC, I think it does help with some clarity, but I think it does still raise potential conflicts with the rules of civil procedure. Ms. Mixon pointed out some of these exemptions, but there is a broader exemption too for anything that's a party has substantial need for that they can't obtain on their own. That's essentially everything. That's any experts' working papers, any experts' reports, any of the underlying data, spreadsheets, again, all things other parties ask for. So rather than create another potential conflict, we think just leave it as is.
Or do you think, Miss, the draft or the recommended language from Miss Mixon still leaves the definition that I think what you're telling me is that it doesn't mention other exceptions to what she's included. Is that what you're telling me?
Right. I think I don't have it in front of me. I think B3 says something to the effect of, protects against the mental impressions or conclusions of an attorney or their witness, unless there's a substantial need or. I'm sorry.
Point it out if you don't mind. I mean, you can read it if this B3.
Yeah, I mean, essentially B3 just says that you can obtain those things only upon a showing that the party seeking discovery has a substantial need of the materials in the preparation of his case, that the party is unable without undue hardship to obtain the substantial equivalent of the materials by other means. I mean, again, that's all the underlying data, the underlying spreadsheets, the underlying formulas, et cetera, that a expert witness submits. Everyone's going to have a substantial need for them, and they can't obtain them on their own. So I think, again, what Southern Environmental Law Center has proposed does help, but then you get in to potential arguing about whether the definition shall not apply to expert working papers prepared for supporting a party's positions or pre-filed expert testimony. Again, I think its intent is to create clarity. I think it also could just create another opportunity to argue about what those words mean. And as the commission again pointed out, past historically hasn't really been an issue with the inclusion of the hearing preparation working papers or attorney work product. And that's the other point I guess I would make, is that any hearing preparation working papers are going to be privileged regardless. So if it's truly a hearing preparation working paper, a party's going to submit an objection that says it's a privilege or it's attorney work product. I think one other piece that I didn't mention, I think that was in our comments, is with the definition including inspections and audit documents, then you start getting into whether the proposed definition lists inspections and audit documents, whether materials that ORS may possess are discoverable or not. Obviously, I believe as their comments reflected, and as statute shows, that ORS gets information from parties, from the utilities at least, rather, under their audit powers, not necessarily discovery. So now if you're saying that a working paper includes audit documents and inspections, does that now mean that those responses to ORS are no longer discoverable? Never had any issues, I don't mean to imply that with ORS, objecting to providing those materials, but I think it opens the door for questions potentially even from a utility, whether ORS can hand those over.
Okay. So I think what I'm thinking at this point is, have you thought about Ms. Mixon's proposal, but also the possible inclusion of a statement that says the terms of this definition, because this definition would fall under 103.804 of our regs if the General Assembly says it's okay. That this definition, I can't think of the exact words I want right now, Mr. Hall, but basically will not or does not conflict with South Carolina Rules of Civil Procedure, Rule 26.
And Jocelyn, I might have to think that through a little bit. I guess, again, our recommendation is just to leave it as it is. Mm-hmm. If you're going to do anything, I was thinking about through this morning to try to offer an alternative. I would eliminate any of the working papers include but are not limited to. One of our original suggestions was just to say working papers shall not be interpreted to mean work papers.
Shall not be.
Something to that effect. It was in our prior comments in the reg review docket.
I can find those. I'll find them on here for everybody to see.
And if you want, and potentially you could then incorporate what Southern Environmental Law Center says, that it's or shall it be interpreted to mean work papers or expert working papers prepared for supporting a party's positions or pre-filed testimony. Though again, I think that's a slippery slope.
Let me find the one and let me just find something right quick. I want to look for what I saw. Wait a minute, where's my oh.
And Jocelyn, I know you all may have come across this in your research too, but I believe in that prior, as I'm looking at it now, the October 2024 letter, we pointed out the new storm damage recovery statute that specifically referenced that the finance order, or that the petition has to include, quote, supporting work papers supporting the petition testimony and exhibits. So that just kind of gets to what we were saying in our prior letters too, that, work papers are the data, spreadsheets, et cetera, behind the conclusions, whereas working papers are things like an attorney or like drafts and opinions. So, and I think that's how historically parties have treated what the regulation said before the word working papers was inadvertently removed.
I was just looking. All right, so I'll find that one later on. So if you said exclude possibly, you're not definitively agreeing to this, but possibly excluding the words work papers, memoranda, all of those examples. Then pick up possibly with the word include prepared for the hearing and the pending proceeding. Don't even give examples.
I would suggest not saying working papers include, but it's not limited to. I would just delete that entire.
All that work we did.
I'm sorry.
I really just tease it. But I understand what you're saying. Okay. All right. So pick up with prepared for the hearing in the pending proceeding or in anticipation of litigation, regardless of the physical form or characteristics, so on and so forth. Leave Ms. Mixon's recommended language shall not apply to expert working papers, and that's based on the rules of civil procedure. Okay, so then what else is left? What else is?
And I would not say I don't necessarily agree with keeping the Southern Environmental Law Center proposed definition. I still I guess if I have to rank my suggestions, Jocelyn, the first one would be leave it as
don't do anything. Yes,
second would say just a statement of what we said in October, that working papers should not be read to mean work papers.
Okay, and so if that part, if those examples are deleted, then it wouldn't say that. If the examples of work papers, memoranda, correspondence, stock, if all of that is deleted, then it still wouldn't be your first preference.
So basically, the regulation, what it says now, I don't know if you've read this or not, but basically 833A right now says any material relevant to the subject matter involved in the pending proceeding may be discovered unless the material is privileged or is hearing preparation working papers or attorney work product prepared for the pending proceeding or in anticipation of litigation. So I would suggest you could keep that alone or add to that working papers shall not.
So, Ms. Purvis, would you display what I have on the desktop? Are you recommending, instead of a definition for hearing preparation working papers or definition for work papers, you're recommending that it sounds like if this would be the second option, not the first preference. The second preference could be amending this 103833 again, but then including additional information about working papers after these words, anticipation litigation.
Yeah, that's again sort of the alternative suggestion.
Right.
That right there, the working papers shall not. I forget what we said before. Shall not.
Well, working papers include.
Shall not be read to mean work papers.
Oh.
Just clarifying there's a difference between working papers and work papers. Again, just referencing our October 2024 letter, that work papers are typically the data, spreadsheets, calculations, and analysis behind proposals, models to report conclusions, whereas working papers are more akin to work product or the mental impressions, conclusions, opinions, or legal theories of an attorney or other representative of a party concerning litigation. And those are generally exempt from discovery under the rules of civil procedure. Again, and the commission regulations already say that if it's not covered, the rules of civil procedure apply. So to the extent someone tried to get working papers, they would essentially, the mental impressions that are, again, are protected under the rules of civil procedure and South Carolina case law.
Okay, that would be your second. Your first is not doing anything. Your second one would be to add a sentence here at the. Thank you, Ms. Purvis. At the end of this, it says working papers shall not include work papers.
Correct.
Okay, and there is no third option, right? I'm not trying to put words in your mouth, but it sounds like that's what you're saying.
Yes.
Okay. Okay, so thank you for right now, Mr. Hall. Dominion Energy, if you don't mind, I'm going to start with you all because you filed first. I think that's the fairest thing to do right now, and then we'll go next to the next person. I think Duke Energy Caroline's and Duke Energy Progress. Please.
Sure. Thank you, Ms. Boyd. The company has very brief comments.
Okay.
When the commission and staff proposed and got approved the changes to 103-833A, the purpose was to broaden the scope of materials that are not subject to discovery in Regulation 103-833A with the inclusion of hearing preparation working papers or attorney work product. We think the definition proposed by staff accomplishes the goal set forth in why you amended 803-833A in the first place. So. That's it.
I'm going to sound ridiculous. So you're saying that there is or is no need for the working papers definition, Mr. Anselmo?
Well, I think it aligns with your intent of broadening the scope of materials not subject to discovery.
Okay, got it. Yep. Thank you. Thank you, Mr. Anselmo. Miss Henderson?
Thank you, Ms. Boyd. We appreciate the amount of time that the commission staff has taken to draft this definition in response to the call made by the General Assembly that we clarify the term working papers. We spent a lot of time reviewing the draft definition, and we agree with Dominion and others that the definition proposed by staff is appropriately broad and also aligns with Rule 26 of the South Carolina Rules of Civil Procedure. We also spent some time reviewing the comments submitted by SCLC, and we might be turning to that soon. We don't feel that the recommended changes proposed by SCLC are necessary, and I know Lyle has spent a lot of time thinking about that, so I'll turn it to him to see if he wants to say more.
Oh, okay.
Yep. Thank you, Ms. Boyd. Just want to reiterate our appreciation for the time staff has dedicated to this. I wanted to respond to a few things in DCA's comments. The first was the example that, under this definition, a utility could withhold cost of service models. I would point him to 103-823A3. The commission spent a lot of time with a lot of stakeholder input promulgating this regulation for MFRs. And it requires an electrical utility, for example, to file upwards of 50 schedules with the commission. They must be filed with the commission, must be provided in Microsoft Excel format with all formulas intact. Those are work papers. And expressly included in that is the cost of service study in schedules E1 through 5. So that example is a little misplaced in terms of how a utility might consider it. I don't see how any utility here could argue with a straight face that we don't have to provide that information in the face of that clear and unambiguous regulation. So I think there's a little misunderstanding of what the commission, at least from our perspective, was trying to accomplish with this definition. And that was, as Ms. Henderson said, to align it with Rule 26 of the South Carolina Rules of Civil Procedure. I would note that the case from the U.S. Court of Appeals from the Ninth Circuit on which the department heavily relied was in 2013, but our Supreme Court, as blessed by the General Assembly, actually amended the relevant provision of Rule 26 in 2024. So I think that case is not really appropriate. It's not binding. It's not persuasive. Also from probably the most reverse court in the country. But anyways, in our 2024 amendment, the General Assembly, together with the Supreme Court, made clear that trying to protect those mental impressions of counsel. And so that's exactly what we feel like this rule is trying to do. Earlier, I heard my friend Mr. Hall refer to subsection 3 about the substantial need of the materials in preparation of the case. Well, that's a more general provision. The more specific provision is actually 4, and that's on trial preparation for experts. I'd also note a sentence that was omitted in that explanation from subsection 3 that says, in ordering discovery of such materials when the required showing has been made, the court shall protect against disclosure of the mental impressions, conclusions, opinions, or legal theories of an attorney or other representative of a party concerning the litigation. That's the aim of this definition of working papers. And so I think that it's important that we distinguish between work papers, which we routinely provide with our filings and in support of our direct testimony and our rebuttal testimony, and now probably in support of others, to the parties and throughout the course of discovery, and now with our 2 rate case applications that were just filed. A plethora of information in Excel files with working formulas intact. And this definition does not change that. Working papers and what the commission we feel was trying to prevent disclosure of here is for things prepared for purposes of the hearing that involve the attorney relationship with the consulting expert or the testifying expert on case strategy. And through that rubric, we feel like this definition is appropriately broad, and it is perfectly in line with the South Carolina Rules of Civil Procedure as they were recently amended in 2024 by the Supreme Court of South Carolina with the blessing of the General Assembly. So with those comments, we feel like the definition is fine. I did go back and look at the regulation that the commission did recently adopt with the General Assembly's blessing of 103-833. And subsection A does refer to it as hearing preparation work papers. And so to that extent, I don't necessarily disagree with adding that qualifier to the beginning as SELC did. But I don't think the other changes are necessary. They're kind of throat clearing when you think about the other regulations in place that clarify that work papers are indeed discoverable and in fact mandated so by the 823A3. I don't feel like that's exactly necessary here to clarify. We don't feel like this conflicts with Rule 26, but is in fact in line with it.
Thank you.
Thank you.
Mr. Richard, hold on, Mr. Richardson. Make sure I'm not calling you. Actually, Mr. Richardson, ORS is next if you want to go next.
Well, whether I want to or not, you've called on. So I think a couple things.
Okay.
Roger mentioned that we conduct not discovery, but we seek for information on work papers under 58-455. So that's true. I will say I think we generally agree with the concepts that that Mr. Hall has mentioned. I don't think that. I think I'm a little confused about a few things. One is the definition. Is that just for kind of background information, or is that actually, I think you had mentioned earlier, you would put it in a regulation?
Yeah, this would be in a regulation.
Okay. So, if I look at that definition, if I'm an attorney, I'm going to argue, okay, well, so what's excluded is working papers. That includes audit documents that are prepared for the pending proceeding. So, I mean, I can parse it through. Well, it includes all documents that are prepared for the pending proceeding. Now, and I agree with Mr. Trawick that there are certain specific information that utilities are required to provide pursuant to regulation. But, if I'm going to parse it down, if I get a request for something that, say, an expert has put together, maybe it's not specifically required by regulation, but it's part of modeling or it's part of information that he created that led to his testimony. If we didn't have the ability under 58.455 to get it, then I don't really know how we would get that information that we may need in order to understand, how did they get to a certain number? How did they get to this position? Do we agree with that position? And so it would hamper our ability to be able to tell the commission, yes, we've looked at this, we agree with it, we have no problem, or maybe this is something that we do disagree with. And so, when it says, I think it's getting so specific, and it is specific, but it is also very broad. Okay. And, I think that there's probably no dispute amongst any of the parties as far as when we're talking about attorney work product and attorney working papers and preparing for the hearing, get that. Totally understand that. Nobody, I think, would question that. Right. It's when, you say, not you say, but the definition says in possession of or retained by non-attorney representatives, employees, or contractors. So now I can't ask for documents that were prepared and, for a pending proceeding retained by a non-representative contractor. You parse all that out, then it gets much more confusing and much broader as to what would not be discovered. And so if that's where the commission's headed, then that's certainly the commission's prerogative. But I think it's going to, if we didn't have 58.455, it would impede our ability to be able to ask for information that we typically need in order to do the analysis. And I'm assuming, from Roger's standpoint, the information that they would need to do the analysis. So, to me, the definition is more problematic and creates more confusion. If we're trying to get to what does Rule 26 allow, then maybe we just tie it to Rule 26. Not necessarily recommending that because I hadn't thought through it, but to me, this would limit the ability to understand what the utilities or what, even to that extent, utilities understanding what the other parties' positions would be. And then the last thing I would say is, I'm not aware that the working papers issue has really ever been brought up to the commission. I'm not saying it's very possible it has. Obviously now it's been highlighted, so we have to deal with it. But
okay, Ms. Mushroom, if we go back to, for example, just Rule 26B3, which just references materials, trial preparation materials. What about the language that I think Mr. Hall mentioned earlier, the mental impressions, conclusions, opinions, which was really the basis for us asking the General Assembly to allow us to return the language that was originally in there. It was mistakenly removed. So my question is, I know what staff did. Staff was just trying to, for all of the drafts that we send to that we publish everyone, we want a starting point. We want a place to have a discussion, but we want to have done perform some diligence prior to just standing in front of you and asking you for your suggestions. So that was the reason for the draft. This is what we thought at that time, but we did not mention mental impressions, conclusions, or opinions of a non-attorney representative, employee, or contractor. We could have made this, I think, maybe even more simple than we did, but oh well. Is that what am I reading past what you're saying or not understanding what you're saying about how the staff's proposal maybe is more expansive than what's in Rule 26B3? Like, could it have been simpler just to say the mental impressions, conclusions, opinions, or legal theories of a non-attorney, representative, employee, or contractor?
I have to think about that one. I mean, I think if the goal is to track Rule 26,
of course,
then there are other provisions in the regulation, Commission's regulations, where they just refer to Rule 26 or the Rules of Civil Procedure. So I think there may be a simpler way to do it. I think by trying to kind of reinvent the wheel and come up with your own definition, it just complicates matters.
Okay. We're complicated sometimes, aren't we, John?
Well, I don't.
We take ownership. We'll take that title.
No, and I
but not to complicate y'all's lives at all. I'm just saying,
Yeah, I mean, it's just I can. If I wanted to argue the point, then I would. If I wanted to protect something, then I would say, well, wait a minute. The Commission just adopted this regulation. They said that they wanted to broaden what was not exempt, what was non-discoverable.
Right.
And they added this definition that said working papers include documents that are prepared for the proceeding and are retained by a non-attorney representative. And so if there is a document that an expert has prepared as part of its analysis, it may be for testimony, it may be 6 months in advance of filing an application. If there's some document that an expert or witness or whatever has prepared, then I'd say, you know what? The Commission said you don't get it. That may be what the Commission's looking to do. I mean, I don't know. I think it's problematic if we're trying to get to what's the right answer, what's the right rate, what's the right schedule, whatever it may be, in order to conduct that analysis and present that evidence to the Commission, I think we need to fully understand these very complex matters and how did the utility get to it? Or by the same token, the utility would need to understand how did the department's expert get to it, or SELC's expert get to it, or that's universal. And frankly, I mean, to the extent that we have working papers, if the utility needs to get those, we routinely provide those to the company because we understand the need to understand how we got to where we got. And so if the point is to get to Rule 26, I think there's just an easier way to get there as opposed to trying to craft your own definition. To me, it just adds confusion.
Got it. Okay.
Ms. Boyd?
Yes, Mr. Trey.
Could I briefly address a couple things Mr. Mushton said?
Please.
I certainly hear his concerns about, the audit powers. I think a point on that, certainly this regulation couldn't trump statutory authority that ORS has. So
I'm glad you said that, Lon.
We certainly respect that. Well, Ben knows that as I do. And then another thing, I think what the Commission was getting at here was litigation strategy, and I don't want that to get lost. Like that is what needs to be protected, not work papers that support your direct testimony.
Right.
So when you're putting forth experts, we as the party with the burden of proof or any party proffering an expert has the burden of proving that expert's testimony is reliable and that he or she is qualified. And so there's no incentive to withhold information on that because that's a really easy basis to get a Daubert motion and your expert kicked out.
Okay.
And so I do want to sort of set the table on that so that there's no, insinuation that utilities by supporting this definition are trying to hide the ball. There's no incentive to because that gets your testimony kicked out. I think this is really trying to delineate that line between what is supporting all of your testimony, your positions in the case versus what's your litigation strategy for how to present certain things at a hearing. So I did want to put that marker in.
So quoting one of my favorite movies, I'm going to say, allow me to retort. And I don't think Duke or Dominion would do this. So I don't take that. And I don't think a lot of utilities would. I think there are occasions where some utilities might. My response to that would be, you say the burden of proof, and I agree with that. the other side of that coin is that, that case law tells us that there's a presumption of reasonableness when they come in. And then the burden is then on the other parties to overcome that presumption of reasonableness. And so, I can certainly envision a case where a utility says, look, this is reasonable. This is, the burden has been met by virtue of the fact that these are expenses that we've incurred, and you don't, if we don't have to give you information to back that up, I mean, I can certainly see a case where that would come up. So, and again, it's not anything that I think sitting here today that we probably all generally agree with those concepts. 2 or 3 years down the road, I can see it becoming an issue.
Jocelyn, if I may, could I add a couple of comments here?
Yes, please, Ms. Mixon. Yes.
Thank you. So I should say, we put forward this alternative definition, but we do agree that a definition of this term doesn't seem particularly necessary, and that it could create more problems than solutions. But to the extent that there is one proposed or adopted, needs to be narrow enough to ensure that it's consistent with other regulations and with Rule 26. As to why it's not necessary, Mr. Trawick noted, there are other regulations along with Rule 26 that already delineate what is discoverable. If anything, I think that it adds additional support to the argument that a definition here may be unnecessary. Mr. Muschamp, you mentioned a possible simpler alternative. I think we would have to think through a little bit more about what exactly the language would look like. But if, again, the purpose of this definition is to align with Rule 26, then one way to address that could just be to provide that, again, the definition of hearing preparation, working papers, aligns with the trial preparation materials definition under Rule 26. And we would be happy to follow up after this workshop with additional comments based on some of the discussion here today.
Okay. Thank you, Ms. Mixon. I think I was just I was trying to recall, because we worked on the draft that you all are discussing today. It was over a couple of meetings, internal meetings, and I think our intent, those staff members who worked on it, was to say that the hearing preparation working papers could be in these different forms. That was our purpose. So whereas it may seem like we were trying to complicate it, everyone, we were just basically saying that the form in which if it falls under the 103.833A, the hearing preparation working papers could appear in this manner. That may not be a Word document. It may be in a spreadsheet summary. That's the reason we listed all of those different forms, just so everybody has an understanding. We were not trying to complicate that part. And I don't think staff has an issue if that's a problem with removing that. We were just trying to articulate where we thought, or highlight, or draw a picture of where this information could be included. That's it. That's all. So when we get past all of that, just a description of where this information, the hearing preparation working papers, could be recorded, maintained, however you want to call it. That is prepared for the pending proceeding or in anticipation of litigation. Well, that's right from the regulation. Regardless of the physical characteristics. Once again, just trying to broaden it, but it was also saying the commission staff stating that we didn't know the form, but the form really didn't matter as much. These are examples. And the last part where we say regardless of the physical form, if it's the intent was for prepared for the pending proceeding, anticipation of litigation, and also falls under the mental impressions conclusions in Rule 26B3, that's That's the definition that we were trying to capture. There also appeared to be, I just recall a question about, well, what's the difference? Why do you need the attorney work product and the hearing preparation working paper? So that is the reason we reference it. The working papers here would be for non-attorneys, not attorneys, as Mr. Mushton mentioned. Everybody knows that, whether you're an attorney or not. You tell an attorney something, you talk to an attorney about something, and there's a relationship there. Pretty much that information is privileged. You cannot access it. So the goal was to focus on the non-attorney portion of 103.833. What does that mean? What is actually covered for non-attorneys hearing preparation working papers? I hope I didn't ramble too much there. So, okay, now Ms. Mixon just finished. Mr. Mushton commented. Ms. Edwards and Mr. Green?
Good afternoon. I do want to kind of go back just a moment in time. In the original docket that the commission had, it was 2022 300A. The original concern that the South Carolina Telephone Coalition had has been resolved, and that is with the reg as it currently sits, 103.833A. Our original concern was there was a draft reg that was going to take out and replace hearing preparation working papers with just hearing preparation attorney work product.
Right.
And that was our original concern, is that it was narrowing. And so when this wound its way through, the General Assembly, where we are right now, our clients have been generally okay. I hear, we read the staff's proposed definition for working papers. One question we have is, if there's not been a lot of disputes, should we just maybe sit and see if the definition is needed? That's a question that we just offer for everybody's consideration. Is this maybe a situation where we just wait and see? Do we actually need the definition?
No, this is Tracy. I would just add to that. I think I agree with that. I think it's my understanding then that any disputes would be resolved with reference, I think, to the rules of civil procedure, if there's nothing in the regs that contradicts it. And if that's the case, then I think we're talking about applying the provisions of Rule 26, and we'd start to flesh out working papers and attorney work product and the like, what those mean. Hasn't been a problem, is my understanding, not from us, and I don't think it would be, but if for some reason it starts to become to a level where the commission has to be involved, maybe the need for a regulation is revisited at that time, to sort of take into account what's happened in the meantime. So that's all I would add to what Ms. Edwards said.
Okay. So basically, wait and see if an issue arises. I think what I'm going to possibly do, okay, I won't say that yet. Let's move then to Mr. Richardson.
Thank you. I think all the parties probably said a lot to be said on this, but certainly Piedmont agrees with the two companies and Dominion that the proposed definition is appropriately broad and captures the spirit of Rule 26. So that's all we have to add on that.
Thank you, Mr. Richardson. Okay, Mr. Hall, do you have anything else right now?
The only thing I will add, based on what's been said so far, Jocelyn, is that we keep talking about the spirit of 26, or we also have heard that the commission is trying to broaden 26. So I don't see how both can be true. So broaden the definition of 20, or broaden the exceptions in 26 was from a prior rulemaking. Maybe it's in the language here. I'm not sure I've seen that here, but both can't be true. If we're in line 26, and if Rule 26 in the legislature and the courts that we have these great rules that Mr. Trewick mentioned, why do we need to broaden it? Again, the South Carolina Rules of Civil Procedure provide guidance. The courts have provided guidance. And then just quickly on the minimum filing requirements, very helpful. We think that was we were very happy that the commission did that. Again, we argued back when those came up. Those are things that everyone's asking for anyway. Let's get them up front. But they don't provide everything. They don't provide the underlying data, even on a cost of service model. Mr. Trewick gave one example, return on equity. There are no work papers for return on equity provided in minimum filing requirements. So yes, minimum filing requirements are helpful. They're not the end all be all, and there's additional information that parties would want. So I would just a little bit of response to what's been said. That's all.
Does your Department of Consumer Affairs, once you receive the minimum filing requirements, of course, if you need to, do you all call them data requests too? That's what the staff used to call them years ago.
Ours are just discovery requests, interrogatories, requests for production.
But do you serve those if you need to after you've received the application with the MFRs?
Yes, because like I said, there's additional information, and not every component of a company filing is captured by the MFRs. A good portion of it are. Again, it was a great step to helping get the amount of work done that needs to be done in, you just say 6 months, lately about 4.5 months, between the time a proposed order is submitted. So very helpful, but it's, again, not doesn't provide all the answers.
And I think what you're saying is you think that the proposed draft would limit, if this were to become effective, it would limit the example that we just gave, where you receive an application with the MFRs and then you serve discovery. You think some of the language in the draft would limit what a utility or another party how they could respond to your discovery request? Yeah,
I think it could. And as Mr. Marston alluded to, I don't know that they would, but I mean, you could sit there and read that language. I was very happy to hear Mr. Trewick say that that it's important to distinguish between work papers and work papers, working papers and work papers. So I hear that that they at least acknowledge that. I don't know if I heard Dominion say that. If they want to chime in and agree with Mr. Trewick there that work papers are different than working papers, but so again, I mean,
I do know we were trying the reason for after the initial filing of Article 8 and then the filing from last session was the inadvertent narrowing of 103.833A. And that has been cured by the publication of the new regulation in the May 23rd register. So I don't know. That's the way I took that. I didn't. That's the way I understood it. The broaden. Our intent here was not to broaden. It was to answer a question that was asked during the review of 103.833 earlier this year.
Ms. Boyd?
Yes.
If I could
Mr. Trewick.
correct that, we quoted the commission's language on that, and my understanding is that it was stated that the purpose of the revision was to, quote, broaden the scope of materials that are not subject to discovery, end quote, and to, quote, conform Regulation 103.833A to the South Carolina Rule of Civil Procedure, Rule 26.
Yeah.
So it wasn't to broaden Rule 26. So
right.
Those are two separate concepts.
Thank you. Yeah. Okay. Ms. Mixon, do you have anything else to add right now?
No, I don't have anything else to add.
Okay.
Thank you.
Okay, Mr. Terraini, I apologize. I know it took a minute. Mr. Terraini, what would you please provide your insight today?
It seems to me that I like the idea of just referencing Rule 26. That's what everybody's worried about. Is conforming with the exceptions in Rule 26. Maybe we ought to just reference 26. I realize the rules of civil procedure lurk in the background of the regs, but to the extent that the regs start adopting discovery provisions that aren't in the rules of civil procedure, then maybe it's useful to just reinforce the exception. I also think Ms. Edwards had a point when she said, maybe we ought to just let it shake out. it may not be as big of an issue as we think it is, but lawyers love to object. And I mean, only in the Public Service Commission would we be having a heated discussion over what working papers are versus what work papers are. It's probably a valid concern. And if what we want is Rule 26, let's reference Rule 26.
Mr. Terrain, may I use your brain here for an exercise? So when you say, can you, Ms. Purvis, Ms. Purvis, would you display the draft? I wonder if I should display that. Okay, we'll display staff's draft. Okay. So if we, instead of creating a definition for hearing working papers or working papers, and 103.833A is just perhaps amended to include some additional language after anticipation of litigation.
Yeah, I mean, just don't worry about the definition. Go to A.
Mm-hmm.
If you go back to your draft.
All right. This one. Okay.
Yeah. And maybe where it says it's privileged or it's hearing preparation working papers, unless subject to Rules of Civil Procedure Rule 26, the material is privileged, I think it's what, C and...
I think it's B3, Mr. Terraini. 26.
Yeah, well, it's both. It's the B3 and B4. It's the expert stuff too.
Okay.
But I'm not even sure you need to do that. I mean, again, that's the problem here. If what we're trying to do is have discovery under the Rules of Civil Procedure, then maybe we don't need a discovery regulation. But to the extent that you want it to apply, maybe you'll just say under Rule 26, subject to the exceptions in Rule 26.
What about subject to the provisions of Rule 26?
Subject to provisions of Rule 26, yeah. Because basically what you're trying to do in that reg, I believe, is you're trying to say you can have discovery on Rule 26, and then we have this paragraph B about, when it has to be cut off.
Okay, Mr. Terraini, let me find one other reg, because there is a regulation. Well, hold on one second. Stay there.
Mm-hmm.
Ms. Boyd, I think you're looking for 103.835, which I think is kind of the catch-all. So,
Yeah,
I mean, even if it's silent, or I guess, the 130 or the other reg is silent, it seems like this would be a default position to revert back to for point us to 26.
I agree with that. I'm just saying if you want to reinforce it, I mean, to the extent that you're invading the rules, then you're raising the issue about whether, to what extent you've preempted them. So if you're going to have a discovery, an interrogatory section in your rules, maybe you ought to reinforce that you're not changing what you're changing and what you're not. And in some ways, this raises the broader issue that we kind of grafted this Rules of Civil Procedure stuff onto the older discovery rules of the commission. And they don't always jibe. And then you throw 58.455 in the mix, and we really got a mess, because you got one set of rules for one party and another set of rules for a different party, and somewhere in the middle they intersect if somebody files a motion, for a protective order. Maybe we just need a whole new rulemaking on rules. Start over.
I'm thinking because everyone, I'm just trying to be responsive to what we were asked in that hearing, and I'm trying to figure out the right response.
Ms. Boyd?
Yes, Mr. Treywood.
One thing I thought about is in response to Mr. Torini's comments and others. So I think perhaps the rub here is that hearing preparation working papers is sort of a unique term of art to commission practice. That's not really what you see in the rules of civil procedure. So I don't know that it would necessarily be call into conflict 103-835, which I think is our traditional catch-all. But for to clarify, perhaps at the end of subsection A of 103-833, just add pursuant to Rule 26 of the South Carolina Rules of Civil Procedure. Then everybody knows what we're talking about. We're not getting into disputes over work versus working, and things of that nature.
Because I mean, one thing that I realize, even though we can't practice, employees here are unable to practice, is as a couple of you mentioned, if there is an issue, everybody who practices before the commission is very competent and knows how to file a motion. I haven't seen a motion to compel in quite some time being filed at the commission. So I do like that idea of just adding, just pursuant to the rules of the South Carolina Rules of Civil Procedure, because even if there is a dispute, here's my thinking, even if there's an existing regulation and it's contrary or contradicts law, you still have a right to come before this commission and say, okay, your regulations are not in alignment with what the current law says or whatever. So there's always, I wouldn't call it an out, but it's not like, it's the end of the world. There are remedies when the commission may have created an order and or regulation that does not conform to current law. So our intent, I want to assure everyone, was not to, with our proposed definition, was not to cause confusion. We were really trying to draft a definition that covered the work, I won't say working papers or work papers of a non-attorney, and what those results may look like and where they may be stored and how they may be stored. That was, if you look at the scope of what we drafted, that was our intent, to kind of make it plain for the review process. It's as simple as that. I know some may see it as complicating. It was to simplify it for those persons who have to review the commission's regulations. That was that. But I also realized from the attorney perspective, as I said, if there is something that whether it was in our reg or regulation that you asked another party for and you felt like legally you were entitled to, I know everybody knows how to file a motion with the commission. Mr. Torini, was that you?
Mm-hmm.
Okay, yes, sir.
You raised, hate to get off topic, but you raised a point though about procedure that I just wanted to flag to you.
Okay.
You accurately said that we can file a motion to compel.
Yes.
But and you don't see many, and it's mostly because the parties of the commission are very cooperative when it comes to discovery.
Right.
That includes utilities and non-utility parties. So we don't have that many disputes. But I would say, especially when there are deadlines on proceedings, the motions to compel are an awkward way to resolve these disputes because they take too much time.
Okay.
And this is maybe a suggestion for the commission, or I don't know how to deal with this, but the problem with the motion to compel is, at least in my limited experience, is you file the motion or you file the motion for a protective order from 58-455, and then there may even be a request for briefing, and then there's an oral argument, and I mean, before you know it, that's 2 weeks.
Mm-hmm.
If the commission could devise a procedure to use maybe a hearing officer to resolve these motions, at least in the first instance,
Mm-hmm.
and do more quickly. I think those remedy that might be a more useful outlet to resolve discovery disputes.
Okay.
Just throwing it out there. It's beyond the scope of this, but
No,
just want to be aware.
So that would be that. Well, Mr. Trainee, are you just right now referring only to motions to compel? What other kind of motions do we receive right now? I'm trying to think.
You receive motions for a protective order. In the
Okay.
58.
Yes.
It puts the burden on the utility to object to the ORS's request, although in practice sometimes it goes both ways.
So you're saying maybe a modified procedure where instead of placing it on the commission's agenda, use the hearing officer language that was created in Act 175 and
Yes,
just
ma'am.
allow that dedicated person to rule on those motions that are not dispositive of the issues in the case.
Yeah.
Okay.
Yeah, and under that statute, I mean, you'd still have the right to appeal to the full commission.
Right.
But hopefully that ruling in the first instance might just put the matter to rest, especially where the clients may be more invested in it than the attorneys.
Mm-hmm. Yeah, we do. I see. The commission sees, like you mentioned, confidential treatment, pro hoc vici. I don't really recall others, but well, thank you for that that advice, a recommendation, Mr. Tarini. Streamlined. I'll talk to the chairman about it. I promise. Everyone, may I talk to my what time is it? Has it been over an hour? Okay. I just want to talk to John right quick. I think for everybody's sake, I think what I want to tell John is, John, I want us to talk about just leaning toward what Mr. Trawick mentioned, Mr. Tarini, I think Mr. Mushton just referenced to the rules of civil procedure at the end of 103.833A. So is 10 minutes too long? Okay, we should be done by 8:30. I just want to talk to him, and then if we can come back, everyone. It's 11:13, so maybe around 11:23, please. Thank you. Okay, welcome back, everybody. Welcome back, everybody, virtually. So this is what, and then we hope that you will weigh in, everyone, when we file the notice of drafting and the proposed regulation. And what I will do in the notice of drafting is I will include the proposed language. Ms. Purvis, would you display? Thank you so much. So what I think staff is going to do, this is what staff, and then of course we will provide notice like we have before, so you'll know. It's just amend 103.833A at the end, and after the words "in anticipation of litigation, pursuant to, and as provided in," because I think the words "provided in" are important. Pursuant to, in my opinion, is the legal authority. Provided in is the substance of what Rule 26 says governs what's discoverable and what's not discoverable. Anybody have a problem with that? Those extra words, pursuant to and as provided in Rule 26 of the South Carolina Rules of Civil Procedure? No? Okay. So that's what we will include. When we did the notice of drafting for the last one for 103.833A, we included the language that that we would have included in the proposed regulation. We'll do the same for this notice of drafting. Okay? This has been fun, believe it or not. It really has. We don't get to talk to you all about issues like this, procedural issues like this. And so thank you all seriously for participating today. Thank you for your written comments and your time. There's some more noticed issues next month. And if you're able to participate, we'd love to see you. Procedural issues. Thank you, Ms. Mixon. Thank you, Mr. Turaney, Mr. Anselmo, and Mr. Burgess. We appreciate you participating. Mr. Treywick, Ms. Henderson, you too. Mr. Richardson, good to see you. Ms. Edwards, Mr. Green, good to see you. Mr. Hall, I visited Mr. Hall's office for the first time. I teased, I was telling my staff about y'all's offices and the security. It was pretty funny. Good to see you. And also Mr. Muschin. Thank you for participating today. We'll see you next time.